Okay, thank you everyone for coming. I know travel out there has been very difficult tonight. I'm going to talk about something I've never spoken about before, in that it involves the family court, which normally I would keep well clear of. But I was getting quite a lot of inquiries about TOLATA cases in the family courts, and I would mostly pass it off to one of my colleagues who's now left us. So I think it's just really interesting. And my kind of motivation of this is to speak to the solicitors who only deal in the civil courts, as I do, and to say that if you do get inquiries about a case that is being heard in the family court, don't be quick to dismiss it, because actually the process is incredibly similar to the civil courts. And it's something that is just as easy to take on as it were in the civil courts. I'm finding that civil TOLATA cases are quite predominantly family barristers as well. So I think it is something that spans across both. And I really do think it's something that we can get more work in. So I've just put the starting point in here for if you are in the county court or the high court in civil jurisdiction. I do get a lot of questions about whether to issue in part 7 or part 8. And this has kind of evolved over time, but I have not had any cases recently where I can say I would have recommended part 8. I think I had one case where there was a declaration of trust and we got as far as the trial and turned up and the judge said, "I've seen the declaration of trust. What is the defence here?" And I said, "Well, I just don't know." And it was a litigant in person on the other side, and the judge just had a look at it, saw that there was no pleaded case for duress or undue influence, and summarily decided the matter without hearing any evidence. So that obviously, part 8, great. Otherwise, there is just almost always a substantial dispute of fact, even if you're a claimant and you don't think there's going to be. Make sure that pre-action you find out what the disputes are, because if you do start in part 8, it can become very costly and messy to transfer over. Some judges like to try and adopt a hybrid, but in other cases, you have to go back to the beginning and set out your pleaded case. And quite often at that stage, you've already had to submit a witness statement from your client, which puts you at disadvantage, because obviously at the simultaneous exchange of witness statements is an equal footing. So just as a kind of starting point, if you are in the county court and you come across these, I would say part 7 is the way to go. So, I mean, I don't know if everyone knows this already, but you can't actually issue a TOLATA claim, an isolated claim, in the family court. So quite often I have clients come to me or through solicitors that they've had a letter before claim which says we are going to issue a Schedule 1 Children Act matter along with our TOLATA claim. That can't be done. Children Act matter is family court and TOLATA action is civil court. That is a picture actually of Emma Thompson playing a judge in the BBC series. It's not completely randomly selected. But what I'm trying to put forward here is that the only time that these really come up, and it's becoming more and more common, is if you are representing or you have an intervener. So husband and wife are going through litigation, divorce proceedings, separating up their assets, and then there's an intervener, normally a grandparent or a sibling, but I have also acted for an ex-partner. So it's about trying to figure out which properties are matrimonial assets. And so a common one would be where the grandparent has put money in, maybe bought out an ex-partner and thinks that they have a beneficial interest in the property, but they're not on the title. And in most cases, the wife wants to assert that it's a 100% matrimonial property. And this is becoming certainly more and more common. I'm finding I'm appearing in the family court quite a bit. I think it was 3 times this year on these. So I've put forward, this is back in 2005, so it's not a new thing, but this case here set the ground rules for how family courts want these to be litigated. So this judgment here from Nicholas Mostyn KC set out kind of the basic principles. First, that this is completely different in nature from the financial relief discretion that the judges have in the financial proceedings. So it's really a dispute about ownership and beneficial interest. He went on to say that this must be approached on exactly the same legal basis if it was determined in the Chancery Division. So that's great for us civil practitioners. Third party should be joined at the earliest opportunity. So again, you don't want to find yourself in a position where an intervener is coming in very late and the case might be at odds with how the party on their side, if you like, has presented their case at an early stage in the financial relief proceedings. So what you then have is that it's essentially fully pleaded particulars of claim and defence. It's called the points of claim and points of defence. But you have to then set out exactly what your case is, and then it kind of proceeds in the same way as Chancery Division proceedings. So that's the ground rules, and then that's what the family court has been following. So nothing particularly troubling to a civil practitioner who will have dealt with that process already. Then I want to talk about a case from this year, March of this year. And this is, again, it's family court reported case where applicant wife, it's difficult to remember the names of these cases because they're this one just AW for applicant wife and RH for respondent husband. I thought it was their initials at first, but this is how the family court do it, and it makes it quite difficult to remember these cases. So interveners were the siblings of respondent husband. The respondent husband had lost capacity by the time it came to trial. As such, his evidence in support of his position was much more tricky. His siblings were supporting his position, and they were the ones that gave the primary evidence. So the court explored at length the chronology and the dates of all of these interactions because there were two properties. So the court looked at when the parties married, as in applicant wife and respondent husband, when they married, when the relationship broke down, and then when the properties are purchased, who the legal title owner was, and then why it was in that position. But then in both cases, the title owner changed during the marriage. So why was that done? So it's all about intentions. That's what the court was exploring, the intentions of the parties. This left the applicant wife in quite a difficult situation because she wasn't involved in any of these transactions, so couldn't really give persuasive evidence as to the intentions of her husband and his siblings. But the two properties, one was simply called number 11 and the other number 22. Number 11 was bought in 2011, and at that time, both respondent husband and his brother were on the title. The case on behalf of the husband was that this was actually just entirely his siblings' property, and the husband's name on the title was just for convenience. There was some tax reason. It didn't sound entirely legitimate, but court really doesn't. I'm finding that the court are not too troubled by sketchy motivations such as tax benefits and bordering on dishonesty. They just want to figure out, as between these two parties, what was the intention. So respondent husband hadn't contributed anything. His name was on the title. It had then been removed from the title in 2014, which was around the time that the relationship was breaking down. Applicant wife said, well, they're just trying to take this property out of the matrimonial pot, and she wanted a declaration that the respondent husband had a 50% beneficial interest. Well, quite rightly, the judge did look at that. He said it gave him pause for thought and looked into it, but ultimately said that he accepted the motivation behind being on the title, and the removal of RH from the title was simply trying to regularise the position. So in that property, he held, contrary to the wife's case, that sibling one held 100%. Slightly different decision on number 22. That was as per the wife's case. Judge actually said that the wife was running two contrary arguments, that her case in respect of number 11 didn't help her case in respect of number 22. But she won one, she lost one. So this was a property that respondent husband bought in 1985 with help from his family, who actually lived next door to the property. And then in 2009, the mother of the respondent husband needed funds to compromise a legal action that the family had become involved in. It was actually one of the siblings' ex-wives, and they wanted to compromise the divorce proceedings. In order to raise the funds, respondent husband agreed to remortgage his property, but needed his sister's help in this case to be on that mortgage. The sister went on the title, and I think this, so I've got this slightly wrong. She didn't contribute anything, but she was claiming an interest at trial. She was saying that she'd put some money into it and that her mortgage liability should be reflected in a beneficial interest. The judge wasn't very persuaded by her evidence and held that there was no intention that she have a beneficial interest. Again, it was similar to his finding in number 11, that it was for convenience only. And he held that the respondent husband, in fact, held 100% of that. So that's kind of an indication. And I would say that's quite indicative of the decision on intention. It's not a long judgment, but it does really explore the timeline and what the motivations were. So one that might be interesting to read if you do get involved in these. Quite troublingly, actually, the judgment only, the barristers involved in that. So siblings represented, husband, wife represented. There was only 4 authorities cited. And, from my perspective, when we do these in the civil courts, we each cite about 10 different cases. There's probably 3 that overlap. But, it was Stack and Dowden was cited, and the other 3, I barely heard of them. They were very fact specific. So it was quite odd given the value of these properties and the money involved. So then I just wanted to talk about a case which I did actually just before that judgment. So I didn't have that judgment when we did this case. It was earlier in the year. And I came into the case quite late. The grandparents were intervening. And again, it was 2 properties. And there was one barrister representing both grandparents and husband. So husband's parents, this is. So he was representing them both. And he said that it looked like there might be a conflict of interest. I think because husband actually his credibility was being called into account. He was being alleged of fraudulently preparing a declaration of trust that gave his parents 50% of the interest. They were very elderly. And I think I called him my co-counsel in the end. He rather felt that he needed somebody to take on the case. He actually gave me husband's case, which I think I would have rather been for the interveners. But so he passed that to me a little bit late on in the proceedings. And it was a really interesting decision. And I say it was quite similar to the one we just looked at. So property 1 had been the family home of husband, my client, and his first wife. And then it had become the family home of himself and his second wife. But when he divorced his first wife, his parents bought out her share. So this was the tale. There was some evidence of money moving, but this was a large family and they had a lot of money from the look of things, and there was a lot of money moving everywhere. So there was a declaration of trust that the grandparents had 50% interest, but the second wife who brought this application, she was actually the applicant because she was bringing a case of fraud and an interest in property 2, which I'll come on to in a minute. So second wife said that she had no knowledge of this declaration of trust. The disclosure of it was very late. My client had actually been in prison for coercive and controlling behaviour, and that was why he said he hadn't been able to find the document sooner. It didn't help us that there was a forensic analysis of his computer, and on his computer he'd been Googling how to make a declaration of trust, but that was after he had come out of prison. So there was a lot of concern about his credibility. There was a forensic analysis of the declaration of trust, and again, there were some real oddities about it. But ultimately, the judge accepted it. We even had the witness who witnessed it apparently 20 years prior come to court, and he was incredibly convincing. My co-counsel actually said to me that he felt that he might be an actor because he was so good. He was asked like what he was wearing and all. It was crazy. But I think the judge believed them, and who are we to question that? But ultimately, they got their 50%. Of the family home, which was the big ticket item. But there was another oddity because they owned their own home, the grandparents. And it was a sad story because they had been living in the family home that the 3 children had been born into. So my client and his 2 siblings. The 2 siblings had died in a car accident about 10 years prior to the trial. And the grandparents had decided they didn't want to live in the house anymore that all the children had grown up in. So they bought another house for them to live in their retirement. But they put the husband on the title. They said that was because he had become an only child, and they realised that if they wanted to develop their property later, they'd need his earning capacity to get a mortgage. It was a bizarre motivation because they were absolutely loaded and they hadn't done any work in the preceding 10 years and they hadn't needed a loan or any money. So I think the judge was a little bit more sceptical about that. I felt that was really up for arguing. The difficulty was that in his financial relief proceedings, he'd filled out a Form E. Again, I don't really know much about Form E's. I don't deal with them. But that was the question. Details of who owns the property and the extent of your legal and beneficial interest. He had said 33% in property 2. That's what he put. That's all he put up there. And the next question, if you consider legal ownership as recorded does not reflect the true position, state why. And he'd left that blank. He said this was done while he was in prison and his solicitors had negligently filled it out, but he had signed it. Had plenty of time to read it, and he'd signed it. He then said, well, I didn't understand the difference between legal and beneficial interest. I absolutely have no beneficial interest in my parents' home. Problem was, the declaration of trust on the other property had been drawn up by him, and it had very detailed explanations as to what beneficial interest meant. And so, again, similar to the last case, his position was just contrary on these two cases, and that's what the judge said. So ultimately he said, look, I think the reason that you're on this title is because they didn't want to pay inheritance tax, and they wanted you, they were joint tenants as well, so unity of title. If either of them died, their share would pass to the other two. And the judge said that makes you the intent that you wanted them to be illegal, and him to be a legal and beneficial owner. So we lost on that, but it was quite interesting because on a costs argument, and again, I know family court quite often doesn't delve into cost arguments, but there was huge arguments about costs, took up quite a lot of time, because our position was that the property one was much higher in value. There'd been arguments about fraud, there'd been an expert report, it'd taken up much more of the court's time, and on that basis we should get our costs. I think the judge ended up saying 80% of the time had been taken up by property one and 20% on property two, but he didn't accept that the value was relevant, which again is completely discretionary. I've said very difficult to predict. I mean that both in respect of beneficial interests and on costs, really, because my co-counsel had given advice before I came on board saying that the opposite was going to happen. So he very much felt that the declaration of trust would be found to be a fraud and that we'd lose on that, but that we'd win on the parents' home. I'm not just saying this, I disagreed. I did predict what the judge found, but he had given his client quite strong advice about the other. So it shows, it's very difficult to predict, and everyone has their own ideas when they read the evidence. But I would say on a cost point, again, it's completely discretionary, and you need to get some offers in soon rather than later. And just appreciate that you can't really run one argument on one property and a different argument on the other property. So I'd recommend just really trying to look at the bigger picture, make some offers and get your clients to mediation.